There are various routes a landlord can take to terminating an assured short-hold tenancy agreement. One of those routes is the no-fault eviction procedure. There are various grounds which are no-fault eviction grounds, and the most common one is Section 21 of the Housing Act 1988. The Section 21 notice is also known as Form 6A. This is a notice that can be served on a tenant, giving them notice that they need to leave the let property by a certain date. If the tenant doesn't comply with this notice, the landlord will then have to apply to the court to seek a possession order. Now, this no-fault eviction route is a landlord's mandatory right to terminate an assured short-hold tenancy. And in fact, it's also what defines an assured short-hold tenancy. This type of tenancy provides a tenant with a limited security of tenure, meaning the landlord can terminate it without reason. Now, in order for a landlord to exercise the right to serve a tenant with a Section 21 notice, there are various legal obligations the landlord must comply with. Now, if these are not complied with, the landlord cannot serve a valid Section 21 notice on the tenant until they have become compliant. We'll be looking in this video how a Section 21 notice is correctly drafted and served on a tenant. The Section 21 notice cannot be served on a tenant within the first 4 months of the original tenancy commencing, and it's only valid for a total of 6 months from the date it's served, and it must give the tenant a minimum of 2 months' notice. It is a prescribed form, which means you must use the version of the form that's in force at the particular time you draft your notice. So we'll take a look at what the notice looks like, and we'll show you how this notice is correctly drafted. This is the Section 21 notice, also known as Form 6A. This is a prescribed document, so do ensure you're using the up-to-date version of this form. It can be downloaded from the government website, our website, and many other platforms. If certain obligations haven't been complied with, restrictions can be imposed by law, preventing the serving of a valid Section 21 notice on the tenant. So it's important you seek legal advice before serving this notice. At paragraph 1 of the notice, we'll be inserting the tenant's name. In the case of joint tenants, you'll insert all of the tenants' names here. At paragraph 2 of the notice, you'll insert the notice period. This is the period within which the tenant has to leave the property. After this date, if the tenant hasn't left the property, the landlord can then apply to the court to seek a possession order. Now, it's important that you take into account the method that this notice is being served. In other words, if you're sending this notice by post, you need to allow a few working days, at least 2 working days, before this notice is considered as served upon the tenant. From the date of service of the notice on the tenant, that's when you can calculate your 2 months notice. So in this case, if I was to send this notice out by first class post, as an example, on Monday the 13th of February, we'd be expecting it to arrive no later than the 15th of February. The court rules do state that you must allow 2 clear working days when serving documents by first class post. That would take us to the 15th of April, 2 months later. Of course, there's no problem with allowing a few extra days if you wanted to avoid any doubt. So this is the date here by which the tenant would have to leave the property. It isn't a requirement, but I personally prefer to insert the text in bold. Now, under the date, you'll note reference is made to giving up possession of, and this is where you'll insert the let property address. And again, I'll be putting that in bold. That's not a requirement, it's something I just prefer to do. Paragraph 3 doesn't require any amendments or text to be added to it. This is information simply for the tenant. And at paragraph 4, this is where the notice will be signed. The name of the landlord, landlord's agent or lawyer will be put as the name, along with their address and telephone number, and of course the notice does need to be dated. So once those things are done, the notice could then be served on the tenant. Once the 2 months notice lapse, the landlord then has a period of no more than 4 months to make the application to the court, and that's because this notice is valid for only a total of 6 months from the date that it's served. If the landlord does not make an application to the court within 6 months of serving this notice, the notice becomes defective and it can no longer be relied on. That would mean serving a new notice and having to wait a further 2 months before the notice could be served. You'll also note that there is this capacity section here, and that's where you'll simply tick whether you're the landlord, one of the joint landlords, or the landlord's agent. And that is your Section 21 notice. Although it's a very simple notice to complete, the part that's not always so simple for landlords is making sure that the relevant obligations have been complied with to ensure that a valid notice is being served. There are various legal obligations which, if are not complied with, would impose a restriction on being able to serve a valid Section 21 notice. So it's certainly wise to seek legal advice before serving this notice.